Now, Jennifer, you realize you're muted. Okay, just checking.
I try to mute when I'm not talking always. It's a habit
Okay, that's a good one.
of dogs.
All right, so I guess we'll go ahead and get started. Good evening, everyone, and welcome to the panel discussion on contract negotiation. I'm Dr. Nicole Plenty, double board certified OBGYN and maternal-fetal medicine specialist, and also the current young physician at large to the ACOG National Board of Directors. I would like to start out by introducing our amazing panelists today. Representing Franciscan Health and Indiana and Illinois Health System is Tom Farrington, who has been Director of Physician and Provider Services since 2012. He is the former president of the Indiana Society of Physician Recruiters and current vice president of the Illinois Society of Physician Recruiters. Representing Altru Health System is Jennifer Semling. She is the manager and talent acquisition for this system. Jennifer began her career at Altru Health System as a physician recruiter in 2008. In 2016, she became the manager of provider recruitment, and over the course of the last 8 years has provided oversight to recruitment and staffing of all providers and leaders. And last but not least, representing LifeBridge Health is Dr. Elizabeth Zadzielski, who is a board certified OBGYN and department chair of OBGYN at Sinai Hospital in Baltimore. She earned her medical degree at Rutgers Medical School and completed her residency training at Newark Beth Israel Medical Center. Dr. Zadzielski is an advocate in not only health maintenance, but in disease prevention whenever possible. So to start off our discussion, I'll pose a question to all of our panelists. And I encourage anybody that's watching the panel, if you have questions, please put them in the chat. And if you want them directed to a specific panelist, I'll ask that out loud. Or if you want it to be directed to all the panelists, I'll ask that as well. So the first question is, how does your group respond to contract negotiation? Do your candidates feel they can negotiate? Why or why not? So, Tom, we'll start with you.
Sure. So I think one of the things that we strive for in our recruiting process is to be transparent. So we're trying to educate a candidate during the recruiting phase what our contract looks like, and essentially what the terms are around the contract. So I encourage people to come to us. Our recruiters encourage people to come to us when they get the contract and have questions. I think if you can't honor something that somebody's asking you, you owe it to tell a candidate the why. Why can't we change the non-compete, or why can't we take this clause out? Those kinds of things. So, but I think it's all part of the process as you're kind of introducing your health system to a candidate, is that you're kind of telling them about the contract. But again, sure, people can negotiate, and that's not uncommon to do that. And our job's here to help them navigate that.
Ms. Semling, you want to go next?
Sure, thank you. I agree totally. I think our job is here to try to help to understand the terms of employment as well. I think it's really important to find a middle ground sometimes, and so negotiation is a big part of that. I always tell candidates it's better to ask. We may not be able to meet everything that you're looking for, but if you come in, accept a position, and you have that hesitation, like, I should have asked for this, I should have asked for that, that'll linger. Let's just talk about it. Again, we explain why if we can't meet the expectations, but we do try, and we do definitely try to meet candidates' expectations and to explain why if we can't, or why we can, or what we can do. So I do think it's really important to be able to negotiate, and you shouldn't feel concerned if you ask to negotiate something. I think it's definitely very important.
Dr. Zadzielski, I'm going to pose the question a little bit different to you because you're the chair. So, sometimes, when we're looking for jobs, we're like, do we ask the recruiter these questions, or do we ask the chair these questions? What would you advise people looking for jobs? Do they go directly through the recruiter, or do they contact you directly if they have questions about their contract or the terms?
Yeah, and that is a really good question, Nicole. There are some things that we'll discuss, and I often, as candidates come through, I as department chair will say, yes, we can do X, Y, or Z. And if in fact a question comes through that I would defer to our recruiter, I'll tell the candidate that, I can't answer that specifically for you right now, but I also give them, have the contact information for our recruiters so that that question can get answered within a 24-hour time frame. And I also, as I work with, because we are we have a residency program. So as I work with our senior residents, a lot of people, as physicians, we're not always used to negotiating. That, you're grateful to get into med school, you're grateful to then get into a residency, and then when it's a job, you're afraid to ask those very important questions. And so trying to teach my residents what they should be looking for. And there are those things, as Tom and Jennifer have said, that are your standard terms that, this is where we are. But, other aspects of an agreement are things that we really can negotiate with a potential candidate. Things like, salary, certain types of benefits, in terms of CME, allotment, time away. So those are all very multifaceted, and we try our very best in meeting with candidates to answer those questions as they come along.
So the next question I'm going to pose to Ms. Semling. Are you able to comment on the value of contract negotiation and advise candidates on contract negotiation strategies you've seen to be successful?
Contract negotiation strategies that seem to be successful. I do think when you're looking at like compensation, for example, sometimes there is some set level of compensation. We at Altru have a productivity model, so there is some set things based on market information, but we certainly can look at sign-on bonuses, relocation, maybe time off sometimes that we can negotiate. One thing that Dr. Elizabeth, I can't pronounce your last
Please,
name.
Elizabeth works best.
Thank you. She did share. I do think it's so important when we are negotiating that it is a partnership between our physician leaders and recruitment, because there's so many things that need both sets of expertise. And as a physician-led organization, our physicians will be working directly with those physician leaders. And so it's really important to you create that relationship at that time. Mm-hmm. So as we're negotiating some different things, strategies to negotiate that are helpful, I think it's really important to look at what's reasonable, ask for what you want in a respectful way, and we'll have that conversation. I think also making sure that you share what it is that you're looking for right away, and you expect that we get back to you right away. Like Dr. Elizabeth said, 24 hours, that is reasonable. That's important. The candidates need those answers. And so those are some of the things that we focus on as we're negotiating with different physicians.
Thank you for that. That was a very thorough answer. I appreciate that. So, Tom, since you're like bouncing between two states, I figured this question would be great for you. Can you comment on different contract terms and variations from state to state?
Sure, absolutely. And so Illinois has different kind of foundational employment laws in Indiana. And so sometimes you'll see those reflected in the contract. But I think the biggest thing, and especially given the discipline in which you're all practiced, I think everybody's in OB or a subspecialist, if I'm correct, you really want to think about malpractice. And so different states have different types of malpractice environments. And so Indiana does stake a claim that we're one of the most physician-friendly states in the union in terms of, we had a governor here many years ago who was also a physician, and he put in tort reform. So there's limits And so in Indiana, most health systems are offering occurrence-based malpractice. And what that means is if you leave the practice later, you won't need a tail, right? So it's an investment up front. The other thing that Indiana does in order to kind of help physicians have lower premiums is there's a state, it's a trust, it's the state compensation fund. And so you want to be sure if you're in a state that has a state-funded malpractice fund that your employer is qualifying you in that fund, right? Because otherwise it's like not, I mean, it's kind of like going bare or not having the coverage. Now in Illinois, it's a different story. As you drive, I live in Indiana, but as I drive into the city in Chicago, you get even, 30 minutes away, you see these big billboards and it says, sue your doctor, sue your nursing home, that kind of thing, because Illinois is a very litigious state. And so in Illinois, it's very expensive to write malpractice. And so the standard way that's handled through contracts with our system, and again, most large health systems, is to write a claims made policy. So you want to understand the malpractice in a state where there's, or any contract, honestly, the difference between the occurrence-based and the claims made. So claims made will require you to have a tail if you want to be covered after you leave that practice. And so it's real important to understand those state by state or even practice by practice, and you kind of do your homework and try and understand that. And for example, if you do practice, now we don't employ OBs in Illinois presently, but if you do practice for us in most specialties in an Illinois practice, after 5 years of working for us, we'll take care of your tail, right? So just understand all those terms, I think, is important to understand. And you can do a little research, and but getting good advisors around you to help you understand those things. Does that help?
Yeah. Dr. Plenty, can I expand on that a little
Please.
bit, please?
Sure.
Please.
Yeah, because to Tom's point, that is probably the biggest piece of contract negotiation that candidates really need to be aware of, because of a tail coverage in some cases for an OB can be as much as $150,000 of cost that I've seen. And I've been practicing along the I-95 corridor. So I'm based in Maryland, but I've also worked in Delaware, Pennsylvania, and New Jersey. And it does vary not only from state to state, but as Tom said, from health system to health system. And a lot of private practices, while they may be larger entities, may not be able to afford the cost of an occurrence policy, because for the practice itself, it's much more expensive. So many private practices, so for those who are job seekers, like if you have a practice of like 5 or 6 OBs, they may very well be offering you claims made. And that's a question that is really important for a candidate to understand, because while many of us want to, join a practice and stay there forever, the reality is that many physicians do change practice models several times in their career, and you don't want to have to carry the burden of $150,000 of debt for tail coverage.
So to your point, Dr. Zadzielski, most OBGYNs will switch jobs after 3 years.
Mm-hmm.
Now, Tom mentioned, hey, if you practice with, this certain health system and you have a claims made policy in Illinois, I believe, then they'll cover your tail coverage after 5 years.
Mm-hmm.
Now, when I was in residency a minute ago, I'm not going to tell my age, but I was always told, don't sign a contract if it doesn't provide tail coverage and it's claims made. Right. Is that not standard, Tom, for that to be covered? Is that something people should be looking out for?
Mm-hmm.
Well, again, I think it's all understanding what the offering is. And so our standard practice is a 5-year commitment for us to pay for that. If you work for us 3 years, we'll pay for 60% of it generally, is kind of our practice, right? So we'll prorate it based on your years of service. And so just kind of understanding that, and I would say to some extent, and maybe you do negotiate some of that, and it kind of depends on the critical nature. Now, there are certain specialties. There's another, not that this should be a malpractice primer, but there's another kind of thing that you can get as a slotted policy. And so for something like hospitalists and express care doctors, you can kind of put them in that policy, and it's more portable for them.
Yeah.
But I don't imagine for being OBGYNs that that's so applicable. But for a state where there are workarounds, is guess what I'm saying. But you kind of just need to understand those things.
Yeah,
Gotcha.
thanks. I haven't seen that type of policy for OB, to tell you the truth, Tom. I don't know if you've seen that, Dr. Plenty, or if Jennifer has, but it is an important part of the negotiation process that especially new graduates may not be as aware of as they need to be. So to Tom's point, you really need to do your homework and to ask those questions.
Right.
And can
Now-
I add, I'll add one thing to,
Go ahead.
sorry, could I add your previous question? This is a great example of a piece that was successful in negotiation, because at one point in time of several years back, this was a topic amongst residents and those who were coming on board. And we had a clause where in our state, you wouldn't have to offer tail if somebody was terminated for cause. And so we worked with our legal teams, and now regardless, we will cover tail regardless of reason, no matter if you worked a day or 20 years. So we do cover that. So that is an example of a negotiation that moved towards an overall change to make it a standard practice for us. And so I just wanted to share that, going back to that other question. And then one other thing I thought I'd mention is malpractice is very important, but the other piece that as you're working from state to state, and we don't have a lot of this, is really watching in contracts for that non-compete. There's a few states that non-competes are enforceable, but it's overall most states non-competes are not enforceable. But I have seen where systems have put them in contracts even though they're not enforceable. So I would advise to watch for that and to take a look at the non-compete, and if there's a non-compete in your contract, and make sure that that's an enforceable clause.
And if I can speak to that, so an interesting, go ahead.
There's another question about tail coverage specifically, but go ahead, Tom.
I was going to say to the non-compete. So, and I think it's pretty common for most health systems or practices to have a non-compete just to protect the investment they make in a new physician joining their group. So again, I mentioned Indiana is a very physician-friendly state. There's the state legislature passed, I think, in the year 2020, or it went into effect in the year 2020, that if you're a physician who is employed in Indiana, you have to have an opportunity to buy yourself out of your non-compete. And that was not the case before. So now part of our contract is an exhibit that says, here's an iteration of what it might cost you to buy out of your non-compete. And there's no way around it. As somebody employing physicians in the state of Indiana, we have to do that. We don't have to do that in Illinois, right? So again, understanding if there's a state a state statute that affects your employment law, and that's kind of, I said that early in the conversation, then I got dissuaded, but employment law is different by state. And some states say, yeah, you can't have a non-compete in this state. So just kind of do your homework, that kind of thing.
Because it's interesting you should say that, because I was in a situation in one state where we had hired a physician from another state, and he was within the non-compete radius from his former employer, and they enforced it. So it does vary with each situation.
And I will say, with the non-compete, people do need to make sure they know what that means too. Like, is it 15 miles from every facility associated with the company, or is it just where you've touched? Just to make sure that's in the contract as well.
Right. Yeah.
Addie said that in New Jersey. Go ahead, Dr. Zadzielski.
15 miles is different in Montana than it is in Manhattan. That's all I'm going to say.
Yeah, definitely. Addie asked, in New Jersey, she said there's a TEL plus malpractice. Does that cover you if you leave? Does anybody know about a TEL plus malpractice?
I wonder if it's malpractice plus a tail.
Yeah, I think that must be what it is. If it's
Yeah.
TEL plus malpractice, it should cover. I mean, that's TEL coverage, so that should cover.
It should.
Right.
Yeah.
Again, I don't think any of us are insurance experts here, so I would just get good advice around that.
Yeah, exactly.
Right.
And sometimes candidates sometimes hire lawyers to review their contracts for them, which is always, if you feel that's a good idea, it really is worth the investment of money just to be sure that you are comfortable and understand all of the terms, because they are written in some, legalese. We can't read that. So
I would encourage everybody
I
watching to do that. Everyone needs to invest in one, hire an attorney to look at your contract. Definitely.
And I'd like to contribute to that if I could. So, and I, through the years, met all kinds of or physicians who had, maybe they have a brother-in-law who does real estate law in Florida or something. So he's not familiar with Indiana or Illinois law, and he's not familiar with employment law, and he's not familiar with medicine. And so, sometimes some of those contracts come back and they're all redlined. But you can choose to work with an attorney, however is comfortable for you. And you might go to them and say, I'd like you to help me review this and give me some talking points. And you can go back and manage that with the employer. And that may save you a lot of money. Or you may say to the attorney, I'd like to hire you and I'll pay you. I mean, you probably will pay an attorney per hour of their time. And if they're going to come back and they're going to negotiate with us, I can't even talk to them. They have to talk to our in-house attorney, right? And so you can kind of choose that. Now, some states, and I know in Indiana, the State Medical Association, they have kind of a package that you can go to them as a resident or fellow or a young physician, and you can say, I'm looking for an attorney. And they have like 3 or 5 attorneys who are like on their books, and they'll do kind of a package deal for physicians who are looking at contracts and say, for a fixed fee, we'll do this for you. And obviously those are attorneys trying to get your long-term business, right, to represent you in the future. But again, they're usually a little bit more familiar with the state law and the state contract,
right,
where, people, you'll see all kinds of real estate lawyers don't know much about your business.
Now, Melissa asked, said, for residents present, what is something you wish you negotiated or asked for in your first contract? So I'm going to punt that to Dr. Zadzielski, since she's a practicing physician. Think back and tell us what you wished you negotiated.
Okay, I can't even remember that far back. I think clarity on time off. I mean, now it's fairly clear in terms of time off is always something. But I can't speak to it, very easily, because, as I said, I've worked with our residents here at Sinai in terms of helping them to look for what they would be. And again, going back to Jennifer's point of being reasonable. I mean, you really can't ask for a salary of $400,000 your first year out. So I would behoove our residents who are coming out to actually look at MGMA. You can Google a lot of the MGMA data that gives you a range of salary for your number of years of experience, and at least use that as a starting point.
So Addie asked, what about restrictive covenants from hospital settings? Is that something that you see in most contracts or more from an office setting? I know that usually it's based on the company. So if you're hospital employed, it would be from a hospital setting. If you're in private practice, it would be from the outpatient setting. But what are you guys' thoughts on that particularly?
Well, as you said, Nicole, some may say from, if you've been in, like, if they have 5 ambulatory sites and you were in each of those sites, it may go from that, at least in the state of Maryland. What about you, Tom?
Well, usually my experience is at most an OBGYN or a surgeon or a proceduralist is usually based at the hospital anyway, in the medical office building next to the hospital. So usually those, they're almost the same address, or they may have, a little bit of a different address, but they're within usually one block of each other. Because you don't want OBs driving 30 minutes across town to do a delivery, right? It's not conducive to their clinic or their schedule. So usually those are they're the same. I mean, if we have a physician who goes maybe to an outreach clinic, we generally don't hold them a non-compete to that location if it's less than half time of what they're spending their time. But again, most OBs are usually plenty busy in their primary clinic that they don't have to. Cardiologists ride the circuit a little bit more or something like that. But I think OBs are pretty busy in their home base that they don't need to travel like that. So I would say usually it's one.
Now, we'll say if you're a subspecialty of OB, like I'm MFM. So my non-compete is for outpatient clinic. It's not with the hospital because I'm not hospital employed. We'll be hospital employed soon, but right now I'm not. So mine is from every clinic that I touch. It's not about the hospital that I get privileges at. So that is something, Addie, you would need to make sure it's clear in your contract. What are the covenants of the non-compete? Like, is it for the hospital sites? Is it for the clinic sites? Or is it for both? Because I'm not really sure what type of practice you're in. Jennifer, anything you want to add?
We don't really deal with this too much because non-competes are non-enforceable. So we haven't had much with restrictive covenants.
Nice.
Simple that way.
Yeah, easy.
Easy. It also depends on the nature of the separation. If it's an amicable separation, then some health systems may just look the other way and not enforce. But if it's not an amicable separation, it could get somewhat nasty sometimes, unfortunately.
Okay, I have one more question right now, and it says, how does your company approach non-salary negotiations, such as education reimbursement, vacation time? Is this usually standard or open for negotiation? I'll give this one to Jennifer.
Okay.
I think it's a bit of a combination, I would say. I would encourage anybody to ask for anything they'd like to negotiate. There is some standardization across, as we have 200 physicians are all employed, and you want to have some equity amongst the team as well. So is time off, CME, different things may be somewhat standard, but there may be some things we can negotiate to meet the needs of the individual. So I would not say no. I'd say we are open to talking about things. The other thing that we learned through negotiation is, as Dr. Elizabeth mentioned, MGMA and different surveys and things like that. We want to make sure we're staying current. So as we learn from those who come in to interview with us, we learn what maybe we need to relook at because maybe we haven't looked at it for a little while, or the market is such that we need to update something. So we do learn from our negotiation process as well. And we, as I mentioned, even with the non-compete, we learn and we adjust when we feel like it's something we need to do that's right and more current with market. So I think we're open and flexible.
Okay, now I'm going to ask you guys to tell your secrets. Go ahead, Tom, before I ask for all the secrets.
Well, I was going to say one more thing following Jennifer. So you don't want to be here 3 years and then know that another candidate came in behind you and got more time off than you or something. I mean, that will really make you salty later, right? So we want to sit at the table with our providers, our physicians and our providers and say, everybody's kind of on the same schedule. And you get more PTO after 4 years of service or what have you, it's tiered, but you don't want to hear that somebody else, and this, I've been in this 20 years and believe me, 15 years ago, a CEO would play golf with a guy and his son was coming on as a physician and they might cut them a special deal. That's all gone, right? There's there's transparency now. And again, you just don't want to be So as you're thinking about those things and asking for those things, think about what that does to, Jennifer used the perfect word, equity to the group, right? And we want to sit at the table with all of our physicians and say, this is the deal is the deal is the deal, right? Nobody did a one-off.
Right, and you have to trust that the person that you're interviewing with has that fairness, to Tom and Jennifer's point, and see us as your advocate as well, because we go into this hoping that we're building it's the foundation of a longer term relationship, and so how you come into an employment agreement really starts with these initial negotiations.
So what's the most unique thing that you have heard of people negotiating in their contracts that's not standard? For example, I had a friend that negotiated that her MBA was covered into her contract.
Okay.
Anything
we might sometime, if somebody has a leadership passion or interest in being as a physician, wants to be a leader, we might put in their contract that they could, we use the AAPL, American Academy of Physician Leaders, right? So we may agree to send somebody to that with the agreement. I mean, then the other side of the contract is that then they'll go into a role serving as a leader in our organization at a future date or something. Or if we're hiring somebody who's going to be like the section chair or chief, and we know that we've got a need in this person, so we may do something like that. It's not terribly common, but again, we may do something like Dr. Nicole mentioned.
Yep. And that is often coupled with, if the organization is going to fund that for you, there's often a stipulation that you will stay with the organization for X number of years, because, obviously looking to protect the organization as well. Yes, we are all about education and supporting people's advancement, but unfortunately, we don't want you to come get your MBA after 2 years and then go to the competition down the road. I mean, so we have to look at that as well.
It's a retention
Absolutely.
tactic.
I got you. Now, how often if somebody's been there, already signed their contract, and they're listening and they're thinking, okay, I'm not sure if I want to leave my job or not, when should you start renegotiating your contract? So when your contract's up, do you wait until that time to ask for a raise or ask for other things? Or are there standard times that people should ask for a raise or a renegotiation of their contract? I'm going to
so most, I was going to say, a lot of contracts have a certain notice, like you can give 90 days notice, or we can give 90 days notice that we're going to renew the contract or terminate the contract or whatever. And so I would encourage people to understand what their notice period is on their contract and add probably another good 6 to 8 weeks on top of that. So if they want to renegotiate and their term says, they have to give a 90-day notice if they're going to leave, they should probably start that conversation at 120 days with their employer and say, my contract, my negotiation period is in 30 days, so I'd like to work this out. It kind of just raises the employer's awareness to say, oh, yeah, maybe we ought to look at this.
Mm-hmm. Anyone else?
Yeah, and then also to give, because we know how, as Tom and Jennifer are well aware, organizations are bureaucracies. And so it does take a while to get on someone's calendar, to actually meet with them, to have that discussion. And then they have to go talk to finance, and then they may have to go talk to legal. So you really have to give yourself enough time. And also, if I could just, one last tidbit of advice for all of our candidates, realize that the credentialing process itself in any health system is a minimum of 4 months. Yeah. By from if you have a clean application, and then also realize your state licensing can also take several months. So you have to give yourself enough lead time from, you say, yippee, I just signed my agreement. What do you mean I can't start until 6 months from now? So realize that is going to take a significant amount of time just for organizations to process all of that paperwork.
Any key things to consider negotiating with a locums contract for an OB or OB hospitalist practice? Gary asked that question.
It's a whole nother,
Yeah.
do we have another hour? I mean, so I think working as a locums can sound kind of exciting and fun, but I think, so locums companies really are taking a pretty good scrape off of what somebody's making. Now, we use locums at Franciscan. We're not immune to it, but so we don't really know what a physician is getting paid. We know what we're paying the locums company, and we know the physician is not getting that, right? But and probably the physician is not going to know what the hospital is paying the locums company either. They'll know what they're getting paid, but imagine there's a pretty big gap between those two numbers, and so kind of understanding those things. It's not uncommon that a locums who's traveling would get airfare, lodging, you know, maybe a per diem or something like that, or a rental car. I mean, those are common expenses, but sometimes people will sign. We'll have a locums come through that didn't have any of those, and then the company will come back later and they'll say, "Well, hey, we forgot to ask for a rental car," that kind of thing.
And I think going back to our earlier discussion as well, and I haven't seen locums contracts, but I think for your own protection is to understand the nuances of your malpractice coverage. What are you doing? Is it claims made versus occurrence? Because you may or may not be immune to that. And since you are going to be in several different states sometimes with locums, you really need to understand what you're getting yourself into.
Yeah,
I would add to the locum conversation.
Go ahead, Jennifer.
I would add, because we work with locums as well. We work with locums through a firm, as Tom was mentioning, but we also have a couple of arrangements where we have direct contract locums. So there might be options with some systems to work directly with the system, take out that extra layer. That's beneficial both to the physician as well as to the organization, because you can shave off some of those extra costs and turn some of that back to the physician. But as you're looking at that, make sure you understand who's covering the medical malpractice, who's taking that cost, who's covering that travel. Is that written into the agreement? Is this a W-2 or is this a 1099 arrangement? And if it is, what are some of the pros and cons to those types of arrangements? We've found it, while there's a lot of extra work, sometimes where there's a lot of work with the locum companies too, but we've found taking out that extra layer has been very beneficial for some of our locums needs, because the physicians get to deal directly with us. There's more transparency. To Tom's point, we don't know a lot of the things that are happening. We also don't know a lot of the communication that's happening with the locum. So is the message getting muffled or mixed up in between with that extra layer? So we have found some benefit to working with having those direct contracted options, because it does seem to make things more efficient, clearer, and it's more of a long-standing relationship amongst our system. And there is still that flexibility of being a locum as needed, covering as needed.
All right, well, we're just about out of time. So I'll ask each of the panelists if you have any closing words of wisdom before we end. So I'll start with you, Tom.
Well, I just say, if you want to negotiate something, bring all of it in the beginning, right? So don't say, well, let's work through this, and then you come back and you say, now I want to talk about this, right? No, like that is really kind of offensive to and again, we talk about, they're big health systems, and we have the legal team and the finance team, and so if we go to them once and say, well, Dr. Smith is trying to negotiate this, okay, so we work through that, and then we go back again and say, well, Dr. Smith is coming. They're like, wait a minute, So I say, lay it all out in the beginning, right? And and again, be prepared that not everything you ask for you'll get, but I think it's fair to expect that you'll get an answer if it's a no. The why.
Jennifer?
I do think it's important to negotiate. It's important to ask the questions. If you have the question, ask it. Don't be afraid to ask anything. If the system is not responsive or doesn't take your question seriously, that maybe says something about, is this the right place for me? Because remember, this isn't a one-sided process. This is two-sided. This is a two-way street. It's really important that the system finds somebody that is that long-standing partner, but then also for you to find that long-standing partner as a resident or fellow looking for your first position out of training. So I think the openness, transparency, and that communication is the biggest key.
And Dr. Elizabeth.
No, again, just layering on what Tom and Jennifer have already said, the bottom line, have fun. I mean, really, don't take this as something that is so onerous and overbearing. Your future employer is as much a human being as you are, and we want to see you succeed as much as you want to succeed. And we're more than happy to work with you as long as, we're all looking at being reasonable and fair.
Well, I would like to thank our amazing panelists for being here and giving us all encouraging and knowledgeable words of advice. I thank everyone who attended this virtual event. Hopefully you will attend many more ACOG virtual events. Now I encourage you to visit the employer booths that most interest you and chat one-on-one with the employers that are present. Thank you guys for tuning in. Bye. Have a great evening.